from the firm of attorney called Patton Williams Attorneys. Nazri, how are you doing today? I'm very well, thank you. I know we had a bit of a technical challenge today, solely because the sound issues didn't work so well. But let's give it 1 second and we'll start. We'll be ready to go.
Yes.
Nazri, I'm just putting your sound on quickly. 1 second. I must just get this thing to work. Okay, there we are. I didn't test it. Okay, now your sound is perfectly. Nobody heard what you said early on. So, Nazri, how are you today?
Again, I'm good, thank you. Thank you very much. How are you on that side?
I am very, very well. Everything working okay. The sound is good and the signal is good, and we're ready to roll. So, Nazri, today's topic, interesting topic, and I would like to deal and follow up on our previous discussions. The attitude a client should have in dealing with their matters. Toughen up. Only Pacific case. When they deal with domestic
Yes.
violence, child custody matters, they need to, have a bit of guts and a bit of, hair on their teeth. What is your view on that topic?
Well, the first thing I think that people should know is that, especially people who are what they call in the United States pro se, that means that you are representing yourself. If you are choosing to represent yourself in a legal matter, remember you are in effect choosing to be your own attorney. So if you're going to be your own attorney, you're going to have to act like your own attorney. You're going to have to do the work that an attorney would have done for you. Okay. Some matters are too complex and too involved for a person to be doing as an underrepresented party, I admit. And then there are certain matters that you can do on your own, like for instance, the maintenance court. You're supposed to be able to do that on your own, although it's not that simple and it's not that straightforward. But the ideal or the intention of the legislature or of the concept of the maintenance court was always that people should be able to do their own matters in the maintenance court. So if you're going to be doing your own matter, you are telling yourself or you are telling me that you're going to be your own attorney. But then I find that many of these people who are representing themselves, they don't act like the attorney in their matter. They are still acting like the aggrieved party. So you have two hats on. You have the hat on as the victim or as the complainant or as the applicant, and you are your own attorney. So they forget that they are now also their own attorney. So you have to not separate yourself from your matter. You can't, it's impossible. That's why it's recommended and preferred that you get an attorney. But if you can't do anything else, you need to accept that you are responsible now for putting your own case before the judge or the magistrate. You are now responsible for the litigation of your own case. And if you're going to be litigating your case and you want to win it, then you obviously need to do what an attorney would have done, which is usually you start with your research. So going to court, not doing your research, wanting to represent yourself is like going to run a marathon without having prepared for it. You didn't adjust your diet, you didn't exercise or take test runs or went and jog or whatever you do to prepare for a marathon or for the comrades or whatever. Nobody just shows up at the comrades and starts running. No, there's preparation to be done. So the same with a court case. If you're going to be running your own legal matter, you're going to prepare, you're going to go do your own research, you're going to go see what the court decided in similar matters to yours. You're going to see what arguments you're going to use, and you can't just use an argument, I was hurt and I was pained and he's supposed to or she's supposed to do this. No, the judge doesn't want just your facts. The judge wants legal argument, and on your legal argument the judge is going to, or the magistrate is going to make his decision. So please, if you're going to do your own legal matter, it is crucial and it is paramount and it is plain and simple important that you do your research. If you do have an attorney on record, okay, obviously you've got your attorney that is doing all the thinking, all the research, and is going to present your argument to the magistrate. He knows what facts are relevant, what is not. In that case, it's another story. You're going to depend on your lawyer for that. But then you must still take responsibility of your case by providing your attorney with the facts that he needs, with the information that he needs, with the proof or the documents that he needs, because the attorney just as much cannot just go and rock up at the comrades and start running. No, your attorney needs to prepare. How do your attorney prepare? Your attorney will have a consultation with you, or maybe even more than one. He will ask you for your side of the story. He might ask you for the other side story. What does the other side say? And then he's going to focus and hone in on what do you have that he can use to prove these allegations that you are making. He's going in a maintenance matter. He's going to ask you for your bank statements. He's going to ask you for receipts. He's going to ask you for sometimes even communications between yourself and the other party. He's going to ask you for sometimes even tax returns. He's going to ask you for pay slips. So you can't not take responsibility of your case just because you have a lawyer. Because I can't go and tell the magistrate that my client only earns 5,000 Rand. Where's the payslip? Where's the bank statements? Well, my client is kind of working today and he can't really give me the pay. No, the judge is going to say, sorry, but your word is not evidence. Okay, I need evidence that this is your client's position. So whether you are represented or not, you need to take responsibility of your court case. You are the one driving your case. You are giving your attorney the petrol, the car, the vehicle, the key to the vehicle. Or maybe you're not the one driving. Maybe the attorney is the one driving, but the attorney still needs the car from you, the keys from you, the fuel from you. Okay, you need to take responsibility. Mohammed, I often find it that if clients make emotional allegations, especially, most often these things are not legally enforceable. Meaning, for instance. Let's make just a petty example. My husband forgot my birthday in last year. Okay. That doesn't prove anything. It might prove that he's emotionally unavailable, or that he doesn't really care about things like birthdays and Valentine's Day and whatever the case. But although it hurts you so much that this person who is claiming to love you has forgotten your birthday, the only thing I would need that information for would be maybe as one of the grounds of divorce, which would say, there's no love and affection between myself and my husband anymore. But I would put it in like that. I'm not going to say to the judge, but he forgot a birthday and that is why you should make this order. So this comes now away from taking responsibility. This comes now to the fact of relevance, that certain things are just not relevant. Okay. You are going to increase and inflate your legal bill superficially if you are going to spend countless hours on explaining to your attorney how something made you feel. The judge and the magistrate is not interested in feelings. They are interested in facts, and they are interested in legal argument, okay, and in the law. So your facts might culminate to something like there is a lack of affection and respect. It might culminate to that. But the actual happening, how it made you feel, how you didn't even get a side. But don't insist on putting something in a letter to the other party. You forgot my birthday. Don't insist on put it in pleadings or in affidavits unless it is relevant, and your attorney will tell you what is relevant. So that is basically my in and out about.
A weakness in a case whereby when clients come to see me the first time, They spend the first part of the consultation bad mouthing the other party. And honestly, I get many of these webinars and consultations, I'm doing a lot of them via Zoom as well, is that one party wants to change the other party's personality. And I asked him, how can I do that? I mean, it's impossible. The same way, I know you want to speak, Nazda, give me my 2 minutes. They want to change the other party's personality, and at the same way, I ask him, can he change your personality? Can he make you be a bit more lenient to have keep contact with the minor child? Can he make you a bit more different? He cannot do that. The same way, how can the judge or the court change another party's personality? So those are irrelevant issues. Um, He's all been like going out with his friends, he doesn't give a lot of attention to the minor child when he's in contact with the minor child. The same way you must probably do exactly the same. So focus on what's important, the possibility can he care for the minor child. And when it comes to these type of matters in Nazri, people deal with a lot of petty stuff. Example, I gave him contact. We separated, I gave him contact, but when he has contact with the child cries. Then I come to him and say, why is the child crying? But in the same way, Nancy, I'm certain you are mommy as well. Many times you had a child in your hand, the child was crying. Imagine your husband comes to you and tell you, Nazli, why can't you care for the child? Why is the child crying? Is it natural how the child cries? So I'm going to do the Nazri. I'm with you 100%. Focus on what's important, and and that will give you greater success in your case. Going further, Nazri, I have a lot of questions for you because you're really passionate about these type of matters. You should have become a lecturer, but I think you're a better litigator. Nazri, when it comes to the issue concerning domestic violence and gender-based violence and these type of things, I think that is prevalent now. What is your view as a lawyer? Yes, besides going to the court, should someone toughen up there as well? Should you stand up for yourself? Should you stand up for your rights? Should you just become a victim? What is your view on these type of things?
Yeah. Um, you know what? My first instinct when someone approaches me with regards to domestic violence, I think we have discussed a little bit of this in a previous webinar, where I find that some people are just not ready to let go. And there is nothing that an attorney can do to make you ready to let go. I think it feels so familiar, this topic. I can swear that we've discussed this in a previous webinar
No,
where
Desiree,
I've even explained.
we have
Yeah.
discussed it, but remember some people watch this webinar only and they never watch the previous
Yes,
one.
yes. No, I just don't want to bore people with being repetitive. So if you haven't heard this before, then obviously then it's wonderful. But I don't want to bore you guys. But I mentioned that there are different types of people approaching me. I mean, personality wise, circumstantial, different. I can figure out within the first 5 minutes whether that person is there for help and assistance, or whether that person is there to basically come and complain about their situation, not yet ready to do anything about their situation. And for me, it is important as an attorney who charges for my time that when you come to me as an attorney, I'm not saying you're coming to me for help, because I'm going to call the cops if you're coming for help. Okay, that's the first thing you do when you are anyway in an emergency. You call the police, because this is something I want to explain actually before we dive into the types of people that come to me. An emergency, or when you are in danger, please do not call your attorney. Your attorney cannot take you out of your emergency situation. Again, there is another kind of professional for that. If you are, let's make an example, you are in your home, you and your spouse are in an argument, your spouse starts to get violent, starts to throw things around. Do not call your attorney. There is nothing your attorney can do about your emergency situation. You need to call the police. 10111. Your attorney is not a response worker. Your attorney is there to enforce your rights once you come and see your attorney and say you want this kind of relief. If you are in an emergency situation or in a domestic violence situation, the police is your port of call. I find many times that I get messages at 2 o'clock, 3 o'clock in the morning where the person, not a client, maybe someone that Googled quickly, attorneys, and the person would call me or SMS me or text me at 3 o'clock in the morning saying, please help me. My husband is throwing things at me. Why are you contacting an attorney when you are in danger? When you are in imminent harm's way? A lawyer is not a response worker. They are not there to respond to emergencies where you are in physical harm's way. You need to call the police. So now let's get back to the situation where what kind of people come see me for domestic violence matters. The ones who come and see me are mostly people who are not ready. They just want to come and tell the story. You as the attorney can't do anything. You can tell them their rights. You can say, listen, you need to apply for a protection order. You can do it on your own, or I can assist you with that. Remember to attach that to your affidavit. Remember to attach this to your affidavit. That is what the attorney can advise. But that person will go and you will never hear of them again until maybe a year later or 2 years later, where they come to you and they want to get divorced. And it's the same story. This is what happened. This is what I know the story. You told me this story. So are you ready to get divorced now? You know what? I actually just wanted to come find out what's my rights. But now this person already came to you a year ago for a domestic violence matter. These are people that are not ready, and there's nothing wrong with it. I'm not saying there's something wrong with it. I'm just telling you that when you come to a lawyer and you don't hear what you want to hear, or you are not ready to do what the lawyer is advising you, do not get impatient with us. Why are you here? I mean, that is your remedy. That is the law. The law says that if you are in a domestic violence situation, you apply for a protection order, whether it's financial, economic abuse, or whatever the case may be. So what do you expect the lawyer to do now? If you don't want to apply for a protection order, well, I don't want him to get locked up or her to get locked up because it's the mother. Okay, so you tell me now, what must I now tell you? Because this is your remedy. And then I slowly learned that these people just want to be heard. They want you to listen, and whenever they're ready someday, they will come back to you. So don't think I'm getting annoyed or anything, but I don't want you to get annoyed, you as the person coming to see us, because we can only give you what the law says we can give you. And if you know that already, then I am assuming that you are just coming to see me to hear it again, because we can't give you anything other than that. And then another type of person that comes to see me are people who are slowly moving into the direction of leaving, and they just want to establish their rights, meaning they are now at step one, where they have realized that, you know what, it's not going to work. I'm in a domestic violence situation. Maybe it's not physical at that point, but you can see it going there. And I think I'm going to leave at some point because it can't go on this way. I've already given an ultimatum. So I want this lawyer to tell me, what are my rights should I decide to leave this person? Okay, so now I'm giving you your rights. Okay, I'm telling you, you know what, should this happen, you must apply for a protection order. Put a little bit of money away if you can in a savings account, so just in case you need to get a place to stay. Work out your kids' expenses so long, because you might have to apply for a Rule 43 or a Rule 48 in the magistrate's court. Just get yourself ready. Try to separate some of the assets already. If you've moved out, or if he's moved out, decide now already what you're going to let go, and actually talk to your spouse. Talk to your spouse and see that should it come to that far, how are you going to divide your responsibilities in respect of the children? So these people are people that are coming to prepare for the inevitable almost. Okay. And then there's the other person that comes and says, I have had enough. I'm in a domestic violence situation. He or she has now finally become physical. I was hoping it could change. I've given it 6 months, and I am here to get divorced, or I want to apply for a protection order. I've already spoken to my mother and my sister. They're going to house me for a little bit, and all those kind of things. And what is your deposit? account details, where's your mandate? They sign the mandate, tum, there goes the SMS, deposit is paid. I immediately get onto my settlement agreement. Those are people that are now ready, they're ready to go. So in general, when it comes to domestic violence, the first port of call when you are in danger, when you are experiencing domestic violence in your home, you need to phone the police when harm is imminent. You need to apply for a protection order. You can come to a lawyer later, once you're safe, once you're out of that situation, because the lawyer cannot physically rock up at your house and remove the dangers. That's not our job. We're not trained for emergency responses like that. We do urgent applications, yes, where we will do an urgent application to interdict someone from doing something, or to make someone do something or not do something. But we cannot go for an urgent application at 3 o'clock in the morning to stop someone from throwing an ashtray at you. You can't do that. That's the police job to come and make to remove you or the person, the violence, or make it stop or arrest the person. Nothing that your lawyer can do at 3 o'clock in the morning. And this is another thing that inflates legal bills, because once your client has retained you, they want to employ your services across the board.